Awesome.
Okay, welcome everybody. We are going to be covering we're doing a webinar on the as-is residential contract for sale and purchase. We're also going to cover certain addenda that I believe that you're going to incorporate in your everyday practice. So we're going to start, and we're going to really just go section by section. One of the most important things, which kind of goes without saying, but oftentimes I notice, because oftentimes I'll get the contract, you provide it to me when the contract's signed. And for those of you who don't know, I'm a board certified real estate attorney. There's only about 500 of us in the state of Florida. I'm a partner at the law firm of Ward Damon, and I also am a partner in Lighthouse Title Services. And some of you on the call have already used us, and I thank you and love to continue working with all of you. So it's very important to accurately depict who the parties of the contract are, the seller and the buyer. And one of the things, and I'm going to give you some practice pointers. The first practice pointer is don't get the seller's name from the tax record or from the MLS. Oftentimes the tax record and the MLS doesn't have it accurately depicted. The best place to go to see who the true owner is, and I assume we're just going to, for my assumption is most of you do most of your business in Palm Beach County. So you would go to the Palm Beach County Property Appraiser's website. That would tell you who the owner is, and even to drill down even more, on that site, you can actually click on the most recent deed. The most recent deed will tell you who the owner is. Along those lines, there's different forms of ownership for sellers and buyers. The simple one is if it's just an individual. However, you always have to check the marital status of the seller. Florida, under the Florida Constitution, has a pervasive Homestead Act. It's under the Florida Constitution, and ultimately, if the seller is married, you have to determine if the property is their homestead. Oftentimes, especially if it's in a divorce situation or it's a situation where a party is going to be divorced quickly or anticipating separating or divorcing, what I would always ask for you to be safe is that you would make sure that you ask your seller whether or not they're married, and certainly, to do the extra due diligence, you may also want to check on the clerk of the court website to make sure there's not a divorce pending. I can tell you this is South Florida. It's a sunny place for shady people, and oftentimes people will not provide you an accurate depiction of their marital status. So if they are married, and it's the homestead, you have to get a joinder, meaning that the other spouse has to sign the contract. And the reason why I'm telling you this is every situation I'm telling you about, I've been involved in litigation over, and again, I want to work with you guys on your closings, not on your litigation matters. But I can tell you that this contract has been situations where if we don't have the proper parties' consent, then it's an invalid contract, and the seller down the road could go ahead and try to invalidate the sale of the contract. So the next issue would be if the seller is a corporation or a limited liability company. In that scenario, you have to make sure that the party that's signing the contract has the proper authorization to execute the contract. If it's a Florida corporation, which we don't see too many of them, the preferred form of ownership by entities is LLC, limited liability companies in the state of Florida. So let me talk quickly about a corporation. If the party is the president, then they are authorized to sign the contract under Florida law. If another party, if it's a vice president, a treasurer, or secretary, then you would need a resolution signed by the board of directors and then ultimately by the shareholders authorizing the sale of the property. I think there's a couple questions in the chat room. Let me ask, and I'm going to address Ashley. you would see the marital status. Generally, you would look at the prior deed. It would say the marital status, but certainly you would always ask the clients, and you know, I can send you guys like a checklist of questions that you should ask your sellers when you're taking a listing agreement, because these are things that are very important for you guys just to do your due diligence, because again, you get paid when a transaction closes. And my goal to working with you is to eliminate any potential hiccups that would prohibit you from closing. Correct that the seller's name on the property appraiser site is not always accurate. What you would do again on the actual site when you have the address, the extra step of due diligence is click on the deed, and the last deed will be the last known owner of the property. Okay, so then now moving on to limited liability company. You have, generally speaking, you can look on Sunbiz. The two sites, there's three sites, excuse me, that are always important for you guys to look at when you're taking a listing, when you're executing a contract. Those would be the property appraiser's website, the clerk of the court website, and then Sunbiz. Sunbiz.org lists all the companies. And oftentimes, you know, you may not get you have to make sure that the seller's name is totally accurate. And the way to verify that is you go on the Sunbiz website, you do a quick search. And the other thing is you have to make sure that the company is active. Every year in Florida, an owner of an entity, a corporation, limited liability company, or whatever form of entity, they pay an annual fee to the state for the privilege of doing business. And it's generally due May 1st. If it's not paid by May 1st, it's delinquent. And so when we do your closings, we always check whether or not the company is active or not. But to take the step further before you enter a contract is you want to make sure that the company is an active company, that they paid all their fees to the state of Florida. So when it's a limited liability company, limited liability companies are manager managed or member managed. And the only way to know what form of entity is when you're taking a listing and you have a limited liability company, you want to ask your seller for a copy of their operating agreement. And the operating agreement will tell us who the parties are that can bind the entity to sign a contract. If it's a manager managed company, then the manager has the right to bind the LLC. Now, certain provisions in operating agreements require that if it's a sale of a property, that all of the members also sign a resolution authorizing that. So those are the types of things, again, that kind of falls into my arena. But again, it's always good to do your due diligence ahead of time to make sure that you have the proper party and you have the proper authorization signing the sale. The next form of ownership of a seller would be a trust. And oftentimes the trustee has to sign the real estate contract and ultimately the closing documents. So if you know that there's a trust that owns a property, you have to ask your seller for a copy of the trust, and you can just take a quick look. It's pretty easy to know. You'll see at the signature block or in the beginning of the document which party is authorized to sign on behalf of a trust. The next form of ownership certainly comes within my purview, and I represent a lot of clients probating an estate. So if somebody dies, that's the other thing. You have to make sure, because sometimes the beneficiaries don't tell you. Oftentimes a son or daughter or a surviving spouse will list a property with you, but the party who actually owns the property may have died. And you're not going to be able to transfer the property unless you file a probate in the Palm Beach County courts. And I'm inundated with it now because the attorney in my office that used to handle probate left. So now it's on my plate to do those. So I'm well versed in those issues also. And so in that situation, generally speaking, we're not able to close the transaction until we get orders from the court authorizing the probate. So in that scenario, generally the personal representative of the person who passed away is authorized to sign on behalf of the estate. And then lastly, and this is not, a total list of all the different types of sellers, but the last one is a guardianship. So oftentimes somebody may be deemed mentally incapacitated to manage their affairs. So it's similar that there would be a court-appointed guardian that would sell the property. And this is also common in Florida. We see a lot of probates, we see a lot of guardianships. So you have to make sure that the court-appointed guardian is the one to sign the property. So those are the sellers. The same issues apply also for buyers, but most oftentimes, because again, you guys make most of your money in listings, so I wanted to cover those issues as it relates to seller. Now, the next item is paragraph 1. And so A, you have to you go again to the property appraiser's website. That will give you the information such as the property address, what county the property is located in, and the property tax ID. In paragraph C, which is item 9, the property appraiser has the condensed legal description. To put the proper legal description, you would actually pull up the deed. I can tell you that the tax record always has an incorrect. So I would look first, if you want, I would look to the property appraiser's website and then actually copy the legal description off the deed. If you don't have these accurately portrayed, this is another way where a seller and buyer can get out of the contract. And again, I want you closing deals. I don't want contracts terminating on your behalf. Personal property. This section changed recently. Make sure and read through all of those items. Make sure that your seller wants to sell all of those items. If they don't want to, then put an X through them. And then also list other items. Oftentimes, certain things that you may want to exclude. We see a lot of like chandeliers and other items. The other thing that I will tell you is that oftentimes you're selling a fully furnished home. And what I would do is I would attach an exhibit in line 21, and you'd say, see exhibit A, and you would itemize a list of the items that the buyer is going to buy in a fully furnished sale. Just because I've seen transactions close because people are fighting over, a certain item or a certain piece of furniture, because sellers oftentimes will say it's fully furnished and then swap out certain items before closing. So again, these are practice points to make sure that you're going to close. Paragraph 2, you obviously want to put the agreed upon purchase price amongst the parties. The deposits, keep in mind that a contract is not a fully binding contract until consideration is made, and consideration would be the first deposit. So it's important to put specifically that either the deposit is going to accompany the offer or it's going to be made in a certain time. The escrow agent's name, now keep in mind, the custom in Palm Beach County is that the seller will choose the title and escrow agent, but just because the escrow agent is listed, that doesn't necessarily mean that they're the closing agent. Oftentimes that's the case, but not always. Like for example, I don't believe that you guys hold your own escrow, but certain other brokerage firms, that's smart, Ashley, not to do that. But certain other, like the national brokerage firms, oftentimes they will hold their own escrow. So it may be that the buyer is going to use the brokerage firm. That doesn't necessarily mean that that firm or that title company is going to hold it. So you would put in the additional comments, if you want to have a different escrow agent, you would put in the additional comments when we get there that such and such, like Lighthouse Title Services, which is my firm, they would be the one holding title and escrow. So that's just things to keep in mind. Also in B, oftentimes you'll have an initial deposit and an additional deposit. And generally speaking, 10% is kind of the norm. So you would do 5% and 5%. But again, it's all of these are market dictated. In C, that would be financing, and that could either be seller financing or institutional or other type of financing. And we're going to touch upon that when we get to it. And then the cash to close. Section 3, you want to put enough time so that you can get both party signature, because if you don't get both party signature by the agreed upon date in section 45, then the contract will automatically terminate. Questions? Okay, and I just wanted to address one other comment. For those Dade County agents, and we're going to talk about that when we get to the title section. Dade is the opposite. In Dade, generally speaking, the buyer chooses the title agent. So we're going to talk about the different distinctions when we get there. Okay, paragraph 4. Closing. Now, this is important because this has changed. The closing of the transaction occurs when all funds required at closing are received by closing agent and collected, and all closing documents are delivered. So most importantly, don't ever have your sellers bring a personal check for the cash to close or even a cashier's check, because a cashier's check takes sometimes 1 or 2 business days to clear. So our firm and most title companies, we will only accept wire transfers for the cash to close. Ideally, I would only want wire transfers for both deposits also, because again, there's no adequate consideration until the wire clears. So just as a general rule, have your clients always wire funds to the closing agent and for the initial deposit and the additional deposit. It's very easy. Most importantly though, don't have them do ACHs, because ACHs are not wire transfers. Next section is going to be paragraph 5. The automatic extensions for closing. And this is very important because since 2016, if we're dealing with a lender has to provide the preliminary closing statement to the buyer at least 3 days before closing. And then within 3 days, but within the closing date, the numbers are finalized. But at the very least, all of those lender charges and the title charges are finalized. But the prorations may be slightly different. But that's one way that a closing automatically is extended. And it shall not exceed 7 business days. And this is a new addition to the contract. And then we're in hurricane season right now. So the one thing to keep in mind is you want to make sure that your buyers, if you're representing a buyer, you want to make sure that your buyers have their insurance coverage bound at least a week before closing, ideally. Because right now, if there's a storm that the National Hurricane Center declares, and it's within 3 days from hitting our area, that's called in the box. And if you're in the box, then an insurance company cannot bind the insurance coverage, and the closing will be automatically extended based on this particular section. Also, now going on to paragraph 6. Unless 6B is checked, which means that this property is subject to a lease or an occupancy after closing, and we see this oftentimes with investment properties, short sales, or bank-owned properties, the seller at closing is going to deliver occupancy and possession free of tenants, occupants, or future tenants. And also will remove all personal items and trash, deliver all keys, garage door openers, access devices, and codes. This section oftentimes will inhibit or extend your closings. We want to make sure when you do the walkthrough, and ideally you're doing the walkthrough at least a day before closing, and it sometimes becomes a little sticky if the seller is going to be moving on the day of closing. But you want to make sure there's no tenants there, everything is removed from the property, and you get all keys, garage door openers, and access devices, any gate codes, any clickers that you need to access the gate if you're in a gated community, any clubhouse or pool keys. These are all very, very important. And then sometimes when you're dealing with a seller that may want to stay, because that was pretty common in the last year when sellers were selling at the height of the market, but then if it's an out-of-state buyer, there would be a post-occupancy agreement. It's very important that if you're representing the buyer and the seller is going to remain and retain access to the property after closing, that you have a post-occupancy agreement. This is something an attorney needs to provide. We do them all the time, but you just want to make sure that all the parties understand that there's some issues related to that. And oftentimes, if there's a seller post occupancy period, we hold back a portion of the deposit, the portion of the closing proceeds during that time of post occupancy. The next paragraph is paragraph 7, which is assignability. Generally, in most residential contracts, unless it's an investment property, you would always click the last one, may not assign this contract. However, sometimes if a party is going to form an entity, they may not have the entity formed. So you would check box number 2, which is may assign but not be released from liability on the contract. If you're a seller, you never want to check box 1, which is may assign and therefore be released from any further liability in the contract, because a party can just execute a contract, then assign it, and then even possibly assign it to an unrelated entity, and then you have no control over the transaction anymore. If you're a buyer, you may want to check this box. Always when you're negotiating a contract, it's always important to determine which side you are representing, whether it's the seller or the buyer. Any questions so far on items 1 through 7? Okay, financing. This oftentimes is a big hiccup, so I want to talk in detail about this issue. So obviously, we always love cash transactions because there's no financing contingency. The contract signed, as long as the title's clear and the inspection period passes, then the transaction's going to proceed to closing. However, before you have to do your due diligence before the contract signed. So if it's a cash transaction, you need to verify as a listing agent, does the buyer have the cash to close? Does the buyer have the cash to close right now? So oftentimes you'll require that they have a proof of funds. And you have to look carefully at a proof of funds because this is South Florida, and you're going to hear me say this numerous times during this webinar. South Florida is a sunny place for shady people. I've seen all kinds of crazy things. I've seen fraudulent escrow letters. I've seen fraudulent bank statements. I've seen fraudulent bank letters. So oftentimes you have to look, you take it and you review it with a grain of salt. Also, we have a lot of foreign buyers in Florida. So if you get a bank statement and it's in a foreign currency, that's not acceptable because you have to convert it to the dollars. I represent a lot of clients from South America, and I've handled those from Brazil, Argentina, Colombia, Venezuela, and those are countries that have very heightened political climates. And there could be a situation, not only the conversion rate, but in Brazil, if it's over a certain dollar amount, you have to get government approval to transfer funds out of that country. So always look, and it may be an amazing offer that's well over the asking price, but you have to make sure that these are actually going to come and going to be converted to closing. Also, if you're getting a brokerage account statement, the capital markets are volatile. And so 30 days before closing, they may have a certain amount in their portfolio. But I've represented clients during multiple cycles of economic downturns, and I've seen situations where a portfolio has been cut in half, lost 75% of the value. So again, you have to properly counsel your sellers if we're going to base it on those portfolio figures, that there's a chance that those may not convert into US dollars in the purchase price. Lastly, we're seeing a lot of transactions where, and we're gonna address that later in the webinar, where a property is subject to the buyer's sale of their existing home. And those are something where you always have to be cautious about, because you could be there forever, and you have to make sure that I would never take a contract which is subject to the buyer's sale of a home unless you have a contract that the buyer sale the home, and it's a hard contract, meaning there's no contingencies. Because until that time, you could be up to the day of closing, and if the buyer doesn't sell their home, they can terminate the contract. So those are all the various issues when we're dealing with a cash transaction. The next section, when we're going to go into the financing riders later, is that the contract is contingent upon financing. And so there's conventional financing, there's FHA financing, there's VA financing, or other type of financing. Now, before you're going to accept a contract that's subject to financing, you want to get a conditional commitment from the lender. And what that means is you don't want a letter on a mortgage broker's letterhead that says that they're approved. I used to be a mortgage broker, and we used to write those letters all the time. Those mean nothing. You want to make sure that if they have a mortgage broker, that they put it through, assuming it's conventional, the desktop underwriting system or the Freddie Mac underwriting system, which is the LP, and you get results back saying that they've been approved. If you get that, that means that at the very least, the mortgage broker has pulled their credit report, has taken their income and their asset documents and plugged it all into the system, and it's come back that it's been approved. Because without that, they haven't really done their underwriting, and you don't know if they're truly approved. A mortgage broker wants everybody's business, especially right now with the rates that are at this level. Mortgage brokers are not that busy. So they'll take anybody that comes in, write a letter. And if anybody's a mortgage broker on this call, I apologize. I'm not picking on you. I'm just giving you a real state of the market. So conventional, you have to have desktop underwriting. FHA, you have to also make sure that the lender has underwritten the loan, or at least given us a preliminary approval. Now with FHA and VA also do a property report. And if it's an older property and there may be some issues with the roof or some other properties, ultimately FHA or VA may not approve it. And also there's certain charges that they will require the seller to pay under FHA and VA loans. So those are all things to keep in mind.
Very important, because you don't want to waste your buyer's time if they're doing an FHA or VA looking at properties that are older with older roofs or mold or anything like that, because then they'll spend money on an inspection, they'll spend money, on and maybe on an appraisal and a survey, and then they won't get approved. So very important.
Thank you, Ashley. And then on the next box, generally speaking, right now, because of the interest rates issues, it may be, we see a lot of people checking the fixed or adjustable rate loan. The other thing is when you're representing a seller and you're seeing an initial interest rate not to exceed 4%, you can't accept that contract because the rates are 6 or 7% right now, depending upon the day. So make sure, and it's very easy, you can go on, like, for example, bankrate.com is a pretty good indicator of what the mortgage rates are right now, or any other. Just do a quick Google search and you'll get a feel for what the mortgage rates are. So make sure your seller doesn't sign a contract when an interest rate is not something under no circumstances they would get. Also, you want to make sure that the buyer completes a full application quickly. No more than 5 days. And then keep in mind that there's a loan approval period. And generally speaking, if you're representing a buyer and it's a conventional loan, I have never seen a conventional loan underwritten, closed, and funded less than 20 days. And 20 days is very, very quick. I would, for a safeguard, have a closing if your buyer's getting conventional financing, put it no earlier than 30 days. And if we're dealing with FHA or VA, because there's property inspection reports and there's other underwriting where a FHA or VA loan, I would put it at 45 days out. I've seen FHA and VA loans close within 30 days. That's very quick, like 20 days for conventional. You want to make sure your buyer has wiggle room. And you also want to make sure that the lender has more than enough time to get the approval. Because you have a financing contingency period, if that financing contingency period passes and you don't get a conditional commitment from a lender, then the deposits go hard. So if you're even close, you want to go back to your seller and you want to ask for an extension of the financing contingency period until you get that. Because if not, you could have potential liability if a transaction doesn't close. And we have a lot of litigation over this particular section, and this section has changed dramatically. Now, keep in mind, if your buyer does not provide a termination before the loan approval period, it's going to be very difficult if the lender doesn't perform for various reasons. And lenders will come up with reasons not to provide you a commitment. So I can't stress enough that you must have your loan approval before the end of the loan approval period, or you must get an extension, because if not, your buyer is a great risk for losing their deposits. Any questions about finance? Okay, paragraph 9. And these differ slightly depending upon what county. And really it has to do with the owner policy and charges. Those differ for county. Like for example, in Palm Beach County, the owner policy and charges, and we're going to go into that in more detail, those are generally covered by the seller. In Broward and Miami-Dade County, though there's a Broward and Miami-Dade County provision, which we're going to cover, and those differ slightly. But let's go through those. So, and this is important when you're doing your net sheet, when you're soliciting a listing. You want to be as accurate as possible, because I can tell you, because I'm on the other end of it, when I'm presenting a closing statement to a potential buyer at closing, they will look at the net sheet that you provided and they will start asking me questions on why is this different. They'll also look at the good faith estimate that the lender provided, and they'll ask me why this is different. So it's important to get these as accurate as possible. So a seller will pay documentary stamp tax and surtax on the deed. That's 70 cents for every $100 of the purchase price. The owner policy and charges, which we're going to go into detail when we get to section 9C. Title search charges. Generally speaking, those are out-of-pocket costs that our title insurance company underwriter charges. It's generally around $150. It could be anywhere from $75 to $200. That's a general rule. Municipal lien searches, and that would be a seller charge also. And that's a scenario where it's an out-of-pocket cost that the municipality charges. Like for example, if it's in the city of Boca Raton, the city of Boca Raton charges a fee to look at their records to make sure that there's no code enforcement liens, any water liens, if there's any water owed. And generally speaking, at closing, because we don't get the final water bill, we'll escrow oftentimes a certain amount to cover the last water bill. HOA or condominium estoppel fees. Now, keep in mind, if they are in a project which may have a condominium association fee, there may be a master association fee, there could be a country club, there could be multiple fees. And generally speaking, those are anywhere from about $150 to $250 per association. And if they're delinquent on their assessments, there could be an additional fee that we have to pay to the attorney. Recording costs, Those are just recording fees if there's any satisfactions or other costs. And then if they have an attorney, seller attorney's fees. And then also, we're going to talk about this later, if there's charges for FERPTA withholding, if they're a non-foreign person and they don't fall within one of the exceptions, there's a withholding charge. There's a withholding amount that we would take out of their seller proceeds that we would have to remit potentially to the IRS to cover those costs. Now, costs paid to buyer, taxes and recording fees on their mortgage. Intangible taxes are 20 cents for every $100 of the mortgage. Documentary stamp taxes are 35 cents for every $100 on a mortgage. They would pay recording fees for the deed and the mortgage, owner policy and charges if the buyer is responsible to pay those costs, survey and elevation certificate. If they are getting a mortgage, a lender is always going to require a survey. If they are going to pay any title policy and endorsement costs, those are going to be something that the buyer is going to have to pay. HOA and condominium association application fees, oftentimes if they're applying for approval from association, it could be anywhere from $75 to $250. And then also a lot of associations are also going to require a capital contribution. And oftentimes those are anywhere from 3 months to 6 months of monthly assessment fees. And those are something also, those should be on the MLS listing, but you also should inquire about that, because especially if you have a buyer that's a first-time home buyer, an FHA buyer, or somebody that has really tight finances and you're getting them to the higher end of their qualifications, that could derail a closing. Municipal lien search, if Section 2 is charged, any loan expenses, appraisal fees, inspection fees, all property related insurance, those are all charges that a buyer will pay. And that's something when you're doing your listing presentation, you want to present those all. Or when you're soliciting buyers and when you're evaluating whether or not they can qualify for that certain property. Because as an agent, you guys always get paid, and your goal is to get the highest purchase price possible. But again, you don't want to put a buyer into a property that they're not able to qualify for.
Steve, for the FERPTA, the foreign seller.
Yep.
Is there, do you handle that, or is there a specific attorney that you recommend hiring to deal with that specifically? Because I know it can be tedious.
Yeah, we handle, I personally have a lot of experience in those issues, just with my foreign buyers and foreign sellers. What we normally do is that we work together with an accountant to help us prepare the FERPTA statement, because often there's a lot of different variations as it relates to assuming, because there's a very hard and fast rule. So if a foreign buyer is selling a property that's up to $300,000 and the buyer has an intention to live in the property as its primary residence, then that's an exception for FERPTA. We will not have to withhold the monies for that. But generally speaking, because of the heightened market that we have in Palm Beach County, Dade, and Broward, that really doesn't, that exception is very difficult right now. So oftentimes, most of the purchase prices are over $300,000. And so in that scenario, you would need an attorney that's and a title company that's well versed in that area. So that's something certainly that my office and myself personally can help out.
Okay, good. I just wanted to know, because I have heard of, you need like a specific attorney and accountant to handle
and
that.
That would be me, and I have a team of accountants that I work with along those lines.
Awesome.
And it's not that expensive. Generally speaking, if I do the closing, I don't charge any extra. And then the cost for an accountant to prepare that is like $300 to $750. So it's well worth it to get everything together and make sure everything's done right. Because if it's not done properly, the IRS will get the entire withholding amount. The theory behind that is because a lot of times foreign buyers would never pay income taxes on their properties. So this was a way that the US Treasury would recapture that lost taxes by getting that withholding.
Got it.
Okay, so now moving on to the title related charges. So down here, if we look at Roman numeral little I, this is the custom in Palm Beach County. And in this scenario, the seller is going to pay the settlement fee, the title search fee, and the premium for the owner's policy. The buyer is going to pay the lender's policy and any endorsements. That's the general custom in Palm Beach County and a couple other counties on the west coast of Florida. Roman numeral 2, this is where the buyer is going to choose the closing agent. They're going to pay for all the owner's policy charges and any services related to buyers, lenders, policy endorsements, and loan costs. So in Broward County, this is kind of a hybrid. So in Broward County, the buyer chooses the closing agent, but oftentimes the seller is going to pay for the title search fee, the tax searches, and the municipal lien searches. And in Broward, oftentimes what we see, and in Miami, the buyer chooses the closing agent, but then oftentimes the title company will not prepare the seller's closing documents. So oftentimes we're hired in Broward and Miami just to represent the seller and prepare the seller closing documents. And we generally charge anywhere from, depending upon the complexities, anywhere from like $750 to $1,500 to represent your clients from start to finish. Survey, this is generally a buyer's expense. And even if it's a cash closing, if this is a fee simple closing, which means that it's a single family home or a townhome that's attached, I always recommend that the buyer gets a survey anyway, because they're going to need it if they want to put pavers down on their property, if they want to put a fence down. It's always good, and it's not that expensive on a residential closing that's in a planned unit development community. It shouldn't be more than $400. Home warranties, these are something to always be mindful of, and this is on your seller's closing checklist. You want to make sure that your seller, if they have a home warranty, there's oftentimes a cost that the buyer can pay just to transfer the home warranty. Section F, this is not a special assessment for a condominium or homeowner association. We're going to talk about that shortly. This just has to do with the municipality. So often there could be a situation where the municipality has converted from septic to sewer. If it goes from well water to county water or municipality water, you can look on the tax bill. The tax bill will tell you whether or not there's a special assessment. And I had a closing in Jupiter Farms, which is up north in Palm Beach County, where this happened. And my seller, unbeknownst to her, she was a widow and she wasn't aware that that was a charge on the closing. And we addressed this after closing. There was a slight hiccup, but we were able to do an amendment of the contract to address this. But this was something where we had to get a payoff and the buyer wasn't going to close unless the seller paid all these. And this is not a homeowners or condominium association. This has to do with any type of governmental approval. Now, section 10, these are self-explanatory, and these are all of these sections have been a situation as a result of litigation. Rate on gas, permits disclosure, this is very important, and there's magical language that I'm going to tell you to add in the additional comment section. But when you have a situation, you always want to make sure that you put language, and you can write this down and we'll go over it again when we get to that section, but you want to make sure that if you are representing a buyer, that you put this language, that the seller will pay for the cost of a permit search, and that the seller will agree to close out any open or expired permits on or before the date of closing. Because these are, unless that happens, that is technically a title encumbrance and defect. So your title, your buyer's title insurance policy, unless those are closed out, would have an exception for those permits. Now, sometimes if you're dealing in an investment property, investors will agree to take those subject to those open or closed permits. But as a general rule, you would want to make sure that you have an open or expired lien search. It's very simple. It's part of the municipal lien search. We just check an extra box where they do an open or expired permit search. And certain municipalities are more difficult than others to close out permits. Mold, that's very common. When you are getting a single family home property, and I'm talking about section D, you want to make sure that you also get an elevation certificate. When you do your survey, the surveyor will do it because that will tell you whether or not the property is in a special flood hazard zone, and that's generally flood hazard zone A or flood hazard zone X. Next is energy brochure, lead-based paint, homeowners or community disclosure statement. We're going to talk about that shortly. Section H, this is something that is certainly become an issue. Generally speaking, if you have a property that's an older property and the seller's been in there a long time, you have to make sure that you may be paying property taxes based on the prior tax assessment the first year, but it is going to go up. It could go up to 2% of the purchase price. So if, let's say, if you have a $500,000 property, your buyer could potentially pay the following year up to $10,000. It could go up to be $10,000. So you take 2% of the purchase price. That's a pretty good gauge of what the value of the property taxes could be. Now, keep in mind, there's also a homestead portability where there's a cap on what that could be. So if your buyer is selling their homestead and they take advantage of the portability, there will be an ultimate cap on what their new property could be. But not every seller is taking advantage of that. So just keep that in mind. Paragraph 11, this has the as is section. Paragraph 12, you make sure that every contract is subject to it. Generally, I would never have a buyer have an inspection of less than 7 days because it takes some time to get a home inspector out there to inspect the property. And the other thing to keep in mind, though, is take a home inspection with a grain of salt. The bar to become a home inspector is not very high. It's a very short class. And I've had situations many times where home inspectors have missed things and we've had to litigate over it. So just take it with a grain of salt. And you want to make sure that you say, listen, I am referring you to this person. I am not providing a report of what the property report is. Also, I would always encourage you to get a termite inspection. And if it's a property that there are certain properties that had Chinese drywall over the years, you would want to potentially get a Chinese drywall inspection and potentially a mold inspection. Also, prior to closing, you want to make sure that you do a walkthrough. And if you have an inspection report during the inspection period, you want to basically walk through and make sure that they've satisfied all those items. And oftentimes in an inspection report, when you do an addendum, you want to make sure that you have a proper itemization. If the seller is going to repair certain items, you want to go into detail of what the items they're going to repair is, because generally speaking, prior to the end of the inspection period, one of two things are going to happen. The seller is going to agree to repair certain items, or they're going to give you a credit at closing. So if the seller is going to agree to repair certain items, then you have to make sure those are done before the walkthrough, or you don't move to close.
Another thing to note that's very important in an inspection, especially in Dade County, where there's a lot of older homes, is cast iron plumbing. Definitely make sure you check for that, because that could be a huge deal breaker.
One other item that I want to keep in mind, and then I'm going to touch upon certain warranties given by developers. The other thing to keep in mind, and this only applies in Broward and Miami-Dade County. Palm Beach County doesn't have it yet. Certain municipalities do, but since the Surfside tragedy, counties have really put teeth on their 40-year inspections. What do I mean by that? If a property is older than 40 years old, there's a required reinspection by the county and municipality. If you have a property that's older than 40 years old, you want to make sure that the reinspection has been done, the 40-year reinspection, and that the seller has complied with that. We see this a lot more in condominium buildings than single-family home residences. But if you think about it, 40 years is not that long ago. That's 1983. And there's a lot of properties that are 1983 or older. So just keep that in mind. Palm Beach County does not have a 40-year inspection requirement. I, amongst other groups, have been lobbying for them to institute that, but they don't have it yet. It's beyond me, but that's a fact. So if you're, and related to developers, we can do a separate class on a developer contract, but just to touch upon it briefly, oftentimes if on a new construction, a builder will give you a 1-year all repair warranty, and then there's certain warranties. There's a 5-year on the roof and other items, and then a 10-year on the plumbing and electrical. And then they also will pass on manufacturer or the contractor's warranties. Now, keep in mind, this is something to always important to evaluate, is oftentimes you want to go with a builder that has a lot of experience, because we've seen builders come and go and builders into bankruptcy. I've represented builders in and out of bankruptcy. I've represented homeowners that were trying to get their properties repaired in bankruptcy. So it's also important, if you're buying from a developer, to make sure you do your due diligence. Escrow agent, paragraph 13. One thing to keep in mind, and this is one thing, I guess it may be that I'm an attorney, not a broker. And so I generally like to have my buyers put their deposits in a title company or law firm escrow account. The reason being, if it's in a real estate broker's account, if there's a dispute over the deposit, then the parties can apply to FREC, and FREC will issue an order, and it's hard to overturn that order. I would much rather, being an attorney, if there's a dispute, I'd much rather have it go to litigation. And an escrow disbursement order has no authority over a title company or a law firm, just a real estate, just a real estate broker. So as a general rule, I don't like real estate. No offense to Ashley or any of you, I just don't want a non-judicial body to make a legal determination on who's entitled to escrow.
I do not hold escrow. Please note, I do not hold escrow. Please send escrows to Mr. Wallace.
Okay. The other thing to keep in mind, and this section is very important because this is a section that protects you guys on giving reliance. This is a blanket disclosure that you're not providing any advice on property condition, square footage, facts. This is a very good section for you guys. Dispute resolution. I like this. Okay, so keep in mind that one section that's a little quirky in here is, I'm going to skip to section 16 first, and then we'll go to default second. So the first step is that the buyer and seller, if there's a dispute under the contract, they have 10 days to make a demand for the deposit. If that's not the case, there has to be an attempt to settle. There's a pre-suit mediation requirement. And so oftentimes what I do, if I'm representing a client, I like to strike this, because oftentimes what I see is mediation before a lawsuit is filed. It generally doesn't have any teeth. And again, maybe I'm biased because I'm a lawyer, but I generally don't think that a mediation is that effective until there's a lawsuit filed. Now, oftentimes I'm very persuasive when I deal with demands for deposits and things like that. And oftentimes the fear of a lawsuit will get the parties to settle. But if not, mediation is just an unnecessary amount of money. So let's go back to 15. So in 15, if I'm a seller, I want to make sure that there's you see where my cursor is, without thereby waiving an action for damages resulting from seller breach. I always cross this section out. The reason being is if I'm representing a seller, I only want two remedies. I only want them to get the buyer to get their deposit back or sue for specific performance. Now, if it's a seller's market, I want to even cross out the section where my client can be sued for specific performance. I only want to, if the seller defaults, I just want to give them a deposit back and move on to the next highest buyer. Now, if I'm a buyer, it's different. If I'm a buyer, I want to make sure that my buyer can get their deposit back or sue for specific performance, or also if there's damages. Now, keep in mind this section right here, which is very good for you. The portion of the deposit, if any, paid to the listing broker paid upon default, shall be equally split between listing broker and cooperating broker. That's good. If there's a default, you can get your commission. That's wonderful. The next section, any questions about dispute resolution? The next section is attorney fees. Now, the one thing to keep in mind is whoever wins in litigation gets their attorney's fees paid. So that oftentimes is a situation where that you'll dissuade parties from going to litigation. Now we're just going to go quickly over the standards. The first section is title standards, which I can put you to sleep on. Title examinations, the most important thing, and these are all ways to get out of a contract. Look at these dates carefully, because if I'm a buyer and I want to get on the contract, I'm well versed in this contract, and if we don't properly provide these sections, then that's a way for a buyer to get out of a contract. Same thing with survey. Leasing, keep this in mind. If this is an investment property, a seller must provide at least 10 days prior to closing a estoppel letter signed by the tenants. This is another way that people can get out of a contract. This section right here, it can't be any stronger. Time is of the essence. This means that every contract you hold them to the specific time frames. That being said, that every day is calculated calendar days, except for if the day to perform falls on a Saturday, Sunday, or a legal holiday, then it goes to the next business day. But that's only the last day. The next section is force majeure. And if you look really carefully, it not only includes hurricanes, but they've added epidemics or pandemics. The epidemic or pandemics, this was a section in the last few years where we've had a lot of litigation over, because people tried to get in and out of contracts, sellers and buyers, because of the COVID pandemic. And if you look at it, it's not going to be greater than, it's up to 7 days, but it could be, if it's more than 30 days, then either party may terminate the contract. Closing location. The location of closing is going to be in the county where the real property is located. So if it's a Miami-Dade property, but I'm doing a closing, we'll have it done electronically, or we'll have a mobile closer go to Miami-Dade County if the parties want to do that. Also, FinCEN. If your buyer is a cash buyer and they're buying within an LLC, then there may be additional reporting requirements. the title company always handles that, but keep that in mind. And then FERPTA withholding, we talked about that earlier.
Can you lightly touch on 1031 exchange?
Absolutely,
Okay,
absolutely.
thank you.
Okay, paragraph N. So oftentimes if you have investor clients, they will be buying the property in a 1031 exchange. And this used to not be embedded in the contract, but we had so many situations where agents forgot to do the rider that now this is embedded in the contract. So basically, in this situation, the buyer or seller is going to do a 1031 exchange, and there's very finite time frame. So like this is a hard and fast rule. So if a buyer has sold a property and it's their money, instead of them realizing the gain, they're able to defer the gain. And this is only for investment properties. You can't do this for homestead properties. You could do this for vacation rental properties, but not, or vacation homes, but not homestead properties. So if you sell your property, instead of you taking the money, you could transfer the money to a 1031 exchange company, and it allows you to defer the tax liability and roll the income.
So I looked at the proposal, and I had a few questions.
If we can,
Whoever that is, can you please mute?
Okay, it was iPhone 3. And so based on that, a buyer has up to 90 days to identify replacement properties. That doesn't mean you have to close within 90 days. That doesn't mean you even have to close on the identified property, but you have to list a variety of properties that you intend to close on. And then within 180 days from your closing, you have to close on that, or you realize the gain. And this particular section provides that the seller and buyer will cooperate with the party that's entering into the 1031 exchange. And there's just certain documents that the 1031 exchange company requires them to sign at closing. But as long as they don't incur any additional liability or expenses, then the parties will agree on executing those additional documents. Did that answer your question, Ashley?
Yes, and for 1031 exchange, do you also deal with that, or would you be able to refer like a 1031 attorney or?
Right, we represent a lot of clients because I represent a lot of investors in those scenarios. We don't act as the exchange company, but we have relationships. And again, it's anywhere I work with a lot of national title underwriters that serve as those exchange companies. There's a lot of attorneys that hold themselves out as exchangers. I would be very concerned by those because we've seen situations or fly-by-night companies. The companies that I work with are all backed by national public companies, so you don't have to worry about your clients' funds being lost. But I have done thousands of 1031 exchange transactions.
Okay, thank you for going over that, ladies. That's good to know.
Sure. And then the additional terms, generally speaking, I always like to have people, my agents, go into as much detail as possible. You would want to, in the additional terms, if the escrow agent is different from the closing and title agent, you want to write that information in the additional terms. You also want to make sure that you put that magical language that I told you earlier, that seller will pay for a open and expired permit search, and seller on or before closing will close out any open or expired permits. That's the magical. Any other magical language that you like to put in your contracts, Ashley?
What about like code violations?
Right, and then along those lines, we also would put, even though it's a title defect, I also always like to put in there that seller shall pay or release any code enforcement violations or code enforcement liens on or before closing. Even though generally speaking, that's an encumbrance on title, I like to put that extra language in there before closing. And then I also like you guys to put in there, if you have a broker transaction fee, it helps me to put, and also so your client, either the buyer or the seller, is not surprised. I also like you to put that in there. Now, it may be from a sales standpoint, you may not want to put it in there, but I'm just saying it helps me at closing because I'm usually the last line of defense at closing. So it's good for the buyer or the seller to know if there's an additional charge. Okay, now I'm going to briefly touch on the addenda, and then we're going to take about a 5 or 10 minute break, and then we're going to go to the commercial contracts. You guys see the condominium rider?
Yes.
Okay. So there's a couple things that are very important. When you are disclosing, if you're the listing agent, because your seller is required to fill this out, you have to check whether or not it's approved. The association needs to approve the buyer, and then also specifically put in here that the buyer will fill out an application. I would keep it close because sometimes certain associations have up to 30 days to approve your buyer. And especially self-managed associations, they will hold it to the 30 days because it may be, especially if it's an association where there's a lot of part-time residents, sometimes the board may be part-time. So you want to make sure that you give you make sure that the closing date provides enough time for your buyer or seller to become approved. Also, you need to check this box, which the association has a right of first refusal. I cannot close a transaction until I get a written approval, and I need you guys to provide us the original approval where it approves them, and if there's a right of first refusal, that the right of first refusal is waived. Those are recorded behind the deed at closing. Also, you need to know and accurately list, because a buyer can get out of this contract, what the monthly association assessments are. And keep in mind, there could be multiple associations. There could be a condominium association, there could be a master association, and certain older properties, we see it a lot in properties on the water in Broward and Miami-Dade, and also some of the 55 plus communities in Palm Beach County, Broward and Dade, where there also could be a recreational lease payment as well. All of these items need to be listed because those are the items that we need to get the approval for. So when I handle a closing, we seek an estoppel, and we need an estoppel letter from all these associations. For those of you who don't know what an estoppel is, that basically tells us what the seller owes, if the seller's current or not, because if the seller's not current on their monthly assessments, those need to be paid at closing. It also will tell us if there's any transfer fees that are required, or there's any capital contributions that are required by the association prior to closing. Also, special assessments. Now, keep in mind, this is very important. You want to know if there are any mention, and you can request this from the seller or the association, the last 12 months of board of director meeting minutes for the condominium or homeowner association. Because if there's any mention of any pending association, there could be a situation where the association approved a special assessment, but it doesn't happen until 3 or 4 months after closing. We've had situations where the seller has not disclosed that and the buyer's been surprised. And if we don't do our due diligence, you as the real estate broker, the real estate sales associate, could have some liability. Also, it shows any litigation. This particular rider has evolved over the years to cover all of these issues because there's been a situation where there's been a lot of litigation. The other thing, which is a way that the buyer can get out of a contract, you want to always at the contract signing, you want to make sure that your buyer has received a current copy of the Declaration of Condominium, Articles of Incorporation, bylaws and rules of association, copy of the most recent year-end financial and frequently asked questions. because if you don't get it, the contract is voidable within 3 days after receipt of those. This again is a consumer protection standpoint where condominium ownership is really funky because you're relying on a board of directors that may or may not have financial acumen to cover and manage a budget, which could be in the multi-million-dollar range. There are reports every day that comes out. It's not as common in Palm Beach County, but we see it a lot in Broward and especially in Miami-Dade, where board of directors or treasurers have absconded hundreds of thousands of dollars. And the legislature has passed a new act, an amendment to Chapter 718 Florida statutes, which governs condominium ownership. And there's more teeth now in protecting members of a condominium association, but I don't think it's gone far enough. But it's a situation where there's been some protections to prevent those types of situations. And so you want to make sure that you fill in this date, because 3 days after the date, the buyer has to terminate the contract. You also want to make sure if there's an assigned parking space, garage number, dock, that this is particularly spelled out, because at closing, we do an assignment of the parking space, garage, or dock. This is a section right here, the structural integrity report. This is something, these two, B and C, these are things that have been recently enacted as a result of the Surfside tragedy. Any questions about condominium ownership and the condominium rider? The next rider is FHA. As we talked about, there's a different cap on the different fees, and there's an inspection report that FHA requires, and this also applies to VA. There's certain charges that the seller will pay in a VA loan, up to $250. And then both the FHA and the VA provides that there's a certain amount of repairs that a buyer is required to make pursuant to the appraisal. So FHA and VA are a different animal than a conventional loan. This is another requirement. Now, if they're in a homeowner association, which is a townhome or an attached or detached single family home community, this is required. And this also will let you know what the monthly assessments are. If there's any special assessments, similar to the condominium association, these are things that are required to be signed by the buyer and required to be sold by the seller. Sorry, be required to be completed by the seller. This is required if you're in a 55 plus or 62 plus community, because there's other restrictions like age restrictions. And this is something where it's very important. If you have a buyer that's buying into a 55 plus community, it's very important for them to understand what the restrictions are, because there's a variety of different restrictions in these types of communities. This is a section where the closing is contingent on the sale of a buyer's property. I would never advise your seller to accept a contract if the property is not under contract and the contract is not a hard contract, meaning it's past the inspection period and past any other contingency periods. And then last but not least, these are seller financing. And this, generally speaking, we would put the terms of a seller contract. As an agent, you would just negotiate what the terms are. As an agent, you're not allowed to prepare these closing documents. Generally speaking, if a seller is providing seller financing, they would hire an attorney. I've handled tens of thousands of transactions where we prepared these seller financing documents. And then if you have a contract where you know your seller as an attorney, oftentimes attorneys, not myself, but attorneys will slow transactions down. Still get the contract signed, but just put a provision where the seller has a right for their attorney to approve or disapprove the contract. And the other thing which we may start seeing again are short sales. And I've done thousands of these in the economic downturn. It's possible if we go into a declining market, we may see some of those again, but this is a required this is a required rider in a short sale contingency. And I've gone through the contract and the most important riders that you guys may experience. Are there any questions? Okay, we are going to take a 5-minute break. Will that work for everybody? And then we'll jump right into the commercial contract.
Awesome.
You guys can stay on. I'm just gonna get some water, take a deep breath, and move on.
Thank you so much.